attempted first-degree murder, first-degree arson, and malicious burning. These were the charges laid before the jury for which the state bore the responsibility of proving David Crawford was guilty. They presented the computer forensic evidence of Crawford's extensive research on the victims. They presented evidence collected at fire scenes. They had experts in cause and origin explain their assessments and interpretation of fire scenes. They had victims testify. And then they rested. And we would finally get the opportunity to hear the defense strategy for defending David Michael Crawford from these charges. And I have to admit, it isn't the approach I expected. And it didn't work. The defense turned over their client, a former public servant now in his 70s, to the 12 members of the jury to decide his fate, and decide they did. Today we will cover the defense of David Michael Crawford on Crime to Burn. Welcome to Crime to Burn, where we explore the dark, sooty landscape where true crime intersects with arson and criminal negligence. Join us as we sift through the ashes to bring you the story of what really happened. Welcome back. I'm April, a fire protection engineer and former firefighter.
And I'll be coming around the mountain when she comes.
A quick reminder to please leave us a 5-star review and rating. Please subscribe to our YouTube channel, and please follow us on social media on X, Facebook, and Instagram. When you see content from us on any of those platforms, leave a comment, even if it's something like, I liked the last episode, or I can't wait to listen to the next one, because it is a huge help. Getting the algorithmic overlords to see our content is generating interest, and that causes it to push the content out to more people. And folks, that's how we grow.
You could just say, I like corn dogs.
Yeah, I want to know who likes corn dogs. So anything that you can do through ratings, reviews, interacting with our comment, giving us those likes and thumbs up and hearts, and especially if you share our content with your friends, that is a huge blessing and it's a gift, and I cannot tell you how insanely valuable it makes you. So valuable. So please, if you have any constructive feedback or you have anything that you would like to talk to us about, crimetoburn@gmail.com, or reach out to us through DMs on our social media. Also, we would love to hear your case suggestions, and of course, if you have any fire stories that you want to share with us. I did tease you guys last week about some new information that I have, and we are going to get into it, but I am still awaiting investigation reports from these other fires that some people believe Crawford may have been involved with. However, I want to make it clear he's not been charged in any of those fires, and honestly, it's really unlikely that he ever will be charged in any of those fires unless additional evidence comes to light, because the ties to Crawford in those incidents are weak, but they are interesting coincidences. Anyway, I am going to bring that information to you, but I really want to get the investigation reports before, so if I don't get those investigation reports before we wrap up this case, I will do an addendum to this case once I get that. I'm also still hoping anyone in Anne Arundel County might be willing to talk to me off the record about the investigation into Carrie's harassment and why the police seem to have stopped looking at Crawford for those crimes. I also reached out to the Prince George's County Police Department again this week through a different method to obtain any complaint or disciplinary files for Crawford's time that he worked there. So hopefully I'll be able to bring you a new update on that soon. I've also reached out to District Heights again because I still haven't heard back from them. And I heard a new rumor this week.
Ish.
I was informed that, and this is a rumor, I'm not saying this is true, I'm not saying this happened. Somebody said that they heard this, but this person wouldn't have had firsthand knowledge, they heard it as a rumor. At some point, there may have been a disagreement between Crawford and a female employee over maternity leave, and that female employee may have had a garage fire at some point. So if you know anything about that, I'd like for you to email me. My email address is crimetoburn@gmail.com. And I still am trying to verify the rumor I heard that maybe there was a boat fire over some sort of disagreement at some point. crimetoburn@gmail.com. And of course, if you have any knowledge of any other fires that occurred in the Laurel area that you think I should look into, if you think there's some sort of coincidental relationship,
like a ring of fire,
you can email me at crimetoburn@gmail.com. We've discussed 12 fires, 9 families, 2 alleged intended victims, and I'm going to be a little critical here. I'm not a lawyer, so take my criticism with a grain of salt, maybe even the whole salt lick. I know fire. Court procedures, I'm still learning, and I basically know just enough to be dangerous. And I haven't ever followed a court case to this level of detail before. And I know not every witness testimony can be edge-of-your-seat exciting. And maybe this is always how it is, but I thought the prosecution left some room for improvement in how they laid out the evidence and the testimony of witnesses. It didn't all come together for me in a neat and cohesive story until closing arguments, and maybe that's how it always is. But I found that the order of witnesses and testimony and evidence, they were presented in a way that was so confusing and jumped around so much in the timeline that I often had a really hard time remembering which expert was testifying about which fire during that phase of the trial. That said, I do understand that the prosecution was dealing with some time constraints for some of the witnesses. For example, I heard bench conferences where I heard the prosecution talking about the fact that this witness or that one couldn't be available until another day because of another court case going on. And I imagine that scheduling witnesses for a case this big can be quite a spiderweb, and I presume that it isn't easy. But in a case like this, where there isn't just one crime we're looking at, but a whole series of crimes, and we're looking at instances that happened over 10 years, I felt like the fact that everything was presented in this back and forth manner felt really disjointed. And maybe that's just the best they could do with the time constraints they had to work around. But they had the computer forensics expert testify really early in the trial before we got a real feel for all of the fires and what we were talking about. And I feel like this really diminished the power and the effect of his testimony. Because I was hearing all of these things they found in the computers, but I didn't understand all of the fires yet. They'd had opening statements, so they sort of laid out like an outline of what they were going to be telling us. But I didn't know all the details, and so some of the information that the forensics expert presented, I didn't know what to do with yet. And then by the time we got to the fires, I sort of forgot about some of that.
I feel like they might have played that set of cards a little early.
Well, and then I was thinking about it, and like I said, I'm not a lawyer, so I don't know, but I think maybe the reason they had to do that is because they took some of the evidence that they found in his computer, and as witnesses were testifying, they would show them the stuff that had been admitted into evidence and ask them, you know, is this an email you received from David Crawford? Or is this a photograph of your house? And I guess that maybe they had to present it first because they had to establish where it came from and go through the voir dire process in case anything needed to be excluded, or the defense objected to any of it. So maybe they had to do it that way, but because we were dealing with 12 fires over a 10-year span, it made it really difficult to follow and really confusing. But I will say, the closing arguments did a good job of tying it all up in a bow. But there was times during the trial where I was really confused and I would get mixed up on which fires we were talking about. There's times even when they were presenting the case that the prosecution and defense referred to the wrong fires. And if the judge caught it, he would correct them, but there was a couple that the judge didn't catch. So let's review what the prosecution presented. They presented the forensic evidence from the computers and the phones that were seized when they executed the warrant on Crawford's home. This included things like the Spokio searches, map searches, the coded victim hit list that Crawford had in his phone, and the PowerPoint presentation of all the research that he had done for the Richard McLaughlin fire. They presented video evidence from the Marty Fleming fire, the Richard McLaughlin fire, and the Justin Scherstrom fires. They also had evidence collected from the Bud Price fire, the Scherstrom fires, the second fire at the Henderson home, and all of those tested positive for gasoline. We know accelerant was also used in the McLaughlin fire because we have video, and we know the same thing of the Fleming fire. And for the Hawkins and Byrne fire, we suspect accelerant was used. However, because both of those involved a vehicle, they did not collect evidence to test for gasoline. Now, the only thing that tied all of the victims together was that they all knew the defendant or his wife. They were all either family or neighbors or former colleagues or people that had irked Mrs. Crawford, and there was apparently no other common threads between the victims that police could identify. And had there been any other common threads, I'm sure the defense would have found that thread and pulled on it to unravel the prosecution's case, but they did not. In fact, the defense didn't really do much of anything until closing arguments. The defense cross-examined very few witnesses. They didn't put any new witnesses on the stand. They didn't put Crawford on the stand. And they only presented one stipulation and one piece of evidence when it was their turn. If you recall, a stipulation is when both the prosecution and defense agree to what a witness would testify, and so they present it to the jury as a fact that's a foregone conclusion. The stipulation they presented had to do with the shoe that they found at the scene of Marty Fleming's fire, the shoe that had been on fire and stomped out, the shoe that they found some animal hair fibers on, and one human hair. Now, this shoe was examined by the FBI laboratory, and the animal hair was found not to be microscopically similar to the hair of David Crawford's German Shepherd dog, and the human hair that was on the shoe was found not to be similar to David Crawford's hair. So not David's hair, not David's dog's hair.
Alright. Well, that's one piece of evidence.
Well, what that tells me is that I feel pretty confident that if you looked at my shoes, you could probably find a hair on them that's not mine. That doesn't mean it's not my shoe.
Yeah, I'm pretty sure you found some unexpected creatures on my shoes.
What kind of creatures are you walking through?
Like bears and rhinos and monkeys.
Yeah, we do have a rhino problem up here in the mountains.
Well, that's why I wear my rhino-proof boots.
Yeah.
Rhino-repellent boots.
Rhino repellent boots, yeah. I'm just glad we don't have the ostrich issue anymore.
Yeah, it was a hard-won battle, but we prevailed.
All right. So, as I said in my next paragraph that I'm about to read, I don't know about you, but this evidence through this stipulation about the hairs doesn't feel very persuasive to me. I'm pretty sure you can find hair on my shoes. It's not mine. I think it just means that he picked up a hair somewhere else in his gallivanting about and stomping out his shoe that was on fire that stuck around on his shoe. Same with animal fibers. But the defense presented this as, oh, this excludes him from being the one that was wearing the shoe. And I don't think that that's really the case. And the prosecution didn't really harp on it at all because I don't think that they thought it was that big of a deal either.
I mean, if that was a piece of, like another piece of evidence in a chain of evidence that suggested that it wasn't him, then that might mean something.
It might, you're right. And what I wrote here was that maybe I might have considered that enough a reasonable doubt in the absence of all the computer forensic data that they found. And even though I understand that the computer forensic data is circumstantial, it's really strong circumstantial evidence. And I feel like, for me, that's what really does him in. Not the fact that he also wore a pair of shoes at one point that was similar to this pair of shoes.
Yeah, to me it seems like you'd use something like that to tie somebody to something that would be unlikely, not exclude somebody.
Exactly. That's how I felt. However, as we've discussed, it's never the job of the defendant to prove they are innocent. It is the job of the state to prove that the defendant is guilty beyond reasonable doubt. So let's quickly run through all 12 fires in chronological order with a summary of the evidence and the charges related to each fire. So the first fire occurred May 28th, 2011 at 1:30 a.m. This was the Marty Fleming fire in Laurel, Maryland, which is in PG County. Marty was the deputy city administrator. Apparently he was not fond of Crawford, and he had recommended McLaughlin over Crawford for the position of police chief. The defendant allegedly shows up at his house in the wee hours of the morning, dumps accelerant all over the two vehicles parked out front, lights them both on fire plus his pants and shoe, stomps out his shoe, leaves it at the scene, strips himself of his burning pants, dumps those into a storm drain, and leaves behind a lighter and a wooden stick used as a torch to light the fire. The subject was wearing a hooded sweatshirt with the hood pulled tight around his face. We can connect him to Crawford because they work together. The alleged motive is that Fleming didn't like Crawford and recommended somebody else for the position he wanted. The shoe collected at the scene is the same size as Crawford's shoe, and images on Facebook show Crawford wearing what appears to be the same kind of shoe. The hair and fibers on the shoe don't match Crawford or his dog. The video from the fire shows the defendant using bottles that appear to be empty vinegar bottles, which match the types of bottles that investigators found in his shed. And 17 days after the fire, the defendant posted on an online forum asking about pain from his second-degree burns that he'd sustained on his legs 2 weeks prior, which lined up with the date of the fire. And when police photograph the defendant's legs, they find that he has scars on his legs consistent with second-degree burns, which one might presume he got when he set his pants ablaze at this fire. Then the next year, so May 1st, 2012, David Crawford and his wife Mary sell their home in Maryland and move to Ohio. And they lived in Ohio just under a year. April 30th, 2013, they moved back to Maryland to their house in Dunlogan in Ellicott City, which is the neighborhood that they lived in when he was arrested. So there's no fire in 2012. So that first fire was May 28th, 2011. No fire in 2012, 2013, 2014, 2015, and we get to September 5th, 2016 at 5:33 a.m. This was the very first fire at Justin and Miriam Scherstrom's house. This was the fire where there was a spray-painted message outside that actually named the neighbor. Now, the neighbor had surveillance footage that didn't show the perpetrator, but caught the sound of someone pouring a liquid and then the sound of a lighter. Now, we know that Justin and Crawford are related, that Justin is Crawford's stepson, there's the connection, and that the relationship between Justin, Miriam, and the Crawfords was strained. The evidence collected indicated that there was the presence of gasoline, and the hit list on Crawford's phone had the entry that said Justin 3, and we now know that Justin ultimately had 3 fires. Then about half a year later, March 15th, 2017, this is the fire at Erica Burns' house in Howard County of her mother's car. This is the first fire in this court case. He is charged with malicious burning in this case. So Erica knew Crawford's wife. They'd had a disagreement over the term white privilege. The car fire began at the rear of the car, and Crawford's hit list included an entry for white privilege. Now, I went back through the evidence that was listed in the arrest warrant just to confirm this. It doesn't appear that they took any evidence from this car to test for accelerant because obviously it was a car fire, so I'm guessing that the gas tank probably ruptured, which would have contaminated the scene anyway. Also, they didn't bring forward any evidence that Crawford had searched his computer for Erica Byrne like he had with the other victims. However...
malicious burning sounds like somebody took a Yo Mama joke too far.
I'm actually going to explain to you what the elements of the crimes are.
Okay.
So we'll get to that. But, just because they didn't present evidence of Crawford searching for Erica Byrne doesn't mean that he didn't search for it, because he could have deleted the information and it been overwritten. So some of the evidence that they pulled, the forensics expert testified to, that they pulled out of the computer, they would have like an email, but they wouldn't have the date that the email was sent. And that's because the defendant had deleted the email, and the area where it was stored on the hard drive deleted some of the data, but not all of it. So it is possible that he had done searches on her and we just don't have evidence of it. It's also possible that he didn't. So, presenting both sides of that coin.
Yeah, I guess there's a temptation to just start tacking every malicious act of arson onto the dude, but...
Well, I think the fact that white privilege appeared on the hit list was what really tied him to that one.
He did have a special way of pointing people towards what they needed to look for.
All right, so that was March 15th, 2017. 3 months later, June 23rd, 2017, this is the fire at the Antico's house, the chiropractor's house in Howard County. He is charged in this fire also. In this fire, he's charged with arson in the first degree and attempted first degree murder, 5 counts. 1 count for each of the Anticos, Veronica and Russell, 1 count for each of their children, and 1 count for the mother-in-law. Crawford had researched the Anticos on Spokeo and Facebook. They were Crawford's chiropractor. Now, the jury did not get to hear any evidence of any sort of a dispute between them, but I know from a bench trial that there may have been a billing dispute, or this may have just been normal business for the kind of relationship they had. We don't know. But Cairo was listed on Crawford's hit list, and following the fire, Crawford also made multiple web searches for the Anticos, apparently looking for news of the fire.
Man, you got like a bad adjustment or something.
So then on September 29th, 2017, this was the second fire at Justin and Miriam Scherstrom's now vacant townhouse. The fire was exactly the same MO as the first. You can hear the arsonist approaching the rear of the house, pouring liquid, clicking a lighter. And then in this case, the neighbor now had more security cameras, and we can actually see the person responsible fleeing on foot, followed by a silver sedan driving away. Again, Crawford's Justin's stepdad, same motive. We already know the relationship. In this video, the arson is wearing a hooded sweatshirt with the hood cinched around his face, just like in the Fleming fire. He used gasoline. And the entry on the hit list for Justin 3, we know, indicates the 3 fires at Justin's house. A few months later, December 9th, 2017 at 3:17 a.m., this was the first fire at Evelyn and Scott Henderson's home in the Dunlogan neighborhood where Crawford also lived. The fire was set to the garage doors and extended to the house. Crawford tried to reach out to both Scott and Evelyn the day of the fire, in addition to attempting to bully a neighbor into turning over his Ring camera footage. And at the time of the fire, there were 3 people asleep inside the home, including the Hendersons' mobility-impaired daughter. Now, Evelyn had interrupted Crawford at a meeting. Crawford's hit list included the notation Evelyn 2, and we know Evelyn had 2 fires. His phone had a calendar entry for Dunlogan fire, and then he had Spokeo searches and Google Maps searches before the fire of the home and family, and he made multiple attempts to contact the family to discuss the fire investigation and determine their insurance carrier for some reason. And even after Evelyn had hung up on him, making it clear that they were not friends, he let himself into their home that was under reconstruction to take photos, and when Evelyn and Scott needed help getting their power turned back on, Crawford just swung by their house again to look into it for them, supposedly, and then posted all about it on social media.
What a swell fella.
So that was in December, and then the following April 3rd, 2018, at 3:41 a.m., we have the fire at Bud Price's house out in Frederick County. Now, Bud initially thought the fire was the electrical short caused by a broom that fell, but then when he lowered the garage door and saw the fire pattern on the exterior, he realized that the fire had extended to all 3 doors despite the fact that there was brick or stone work between them. So the fire investigator came out, they took samples, and it was confirmed that there was gasoline present. Price had worked with Crawford, and they had had one disagreement that Price can recall where Price overrode one of Crawford's decisions, but it was like 18 years ago. Crawford did reach out to Price the morning of the fire through a private Facebook group and asked for photos of the fire, and then Crawford had done Spokeo searches for Price and mapped his address before the fire, and after the fire, Crawford was searching for news articles about the fire. August 17th, 2018, this was in Howard County. Overnight, someone burned the lawn of the Hendersons' home. And this was the same home that had burned in December, but the fire was determined to be incendiary, and they found a stick with cloth around the end, like the same kind of torch that was used at the Fleming fire. Reportedly, Crawford had been complaining to neighbors about the state of their yard around the time of this fire, but this fire was never presented in court, and I don't know why. He wasn't charged with this fire, wasn't presented in court, wasn't presented as a supporting evidence fire. It just wasn't talked about. Jury never heard about it.
So how do you know about it?
It's in the arrest warrant.
Oh.
So I'm guessing that the defense objected to it being included for some reason or another, and it was excluded. And since they don't have other pretrial motions, I don't know what the basis of that exclusion was. But if you know and you'd like to let me know, crimetoburn@gmail.com.
Yeah, maybe they just figured they had enough things.
Maybe. And the hit list said Evelyn 2. And if this was a 3rd fire at Evelyn's, maybe it actually weakened the prosecution's case a little.
I'll buy that.
Alright, September 22nd, 2018, 3:45 a.m. This was the 2nd fire at Evelyn and Scott's house. They were weeks away from moving back into the house, and someone pours gasoline around the exterior of the front door, and this time the house was a total loss. We already know about Evelyn and Crawford's strained relationship. Crawford also had the date of this fire in his phone calendar as Dunlogan fire. He once again tried to canvass the neighborhood and get neighbors' Ring camera footage, and he reached out to multiple neighbors to discuss the fire and the investigation and attempt to learn where the Hendersons were living and if they were going to be moving back to the neighborhood. And after this fire, a car is seen on the neighbor's Ring footage, but I cannot confirm if it matched Crawford's car or not because they never tell us out loud in court. Then March 3rd, 2019, in Charles County, this is the fire that occurred in the bed of the pickup truck belonging to Alfonso Hawkins II. Alfonso Hawkins didn't know Crawford, but his father, Alfonso Hawkins Sr., did, and Crawford worked with him. Crawford did conduct Spokeo searches, Facebook searches, and map searches for the victim. And after the fire, Crawford made multiple searches for fires in the area where the fire had been set. March 16th, 2019, so just 2 weeks after that fire, At 3:30 a.m., there's a fire at Rich McLaughlin's house, where the dog woke him up and the detached garage adjacent to the house was on fire. The fire did extend to the main house. Surveillance footage shows someone, allegedly the defendant, in a hoodie with the hood pulled tight, which matches what we saw at the Justin Scherstrom fire, matches what we saw at the Flemian fire. He poured out accelerant in bottles that matches the same kinds of bottles used at the other fires. He lights the fire and runs off, and we see a silver sedan that can be driving away. And allegedly the individual walked like Crawford. The video footage, like I said, matches the other fires, including the defendant's swagger and style.
That one shoe swagger.
McLaughlin had replaced Crawford as police chief. The two did have disagreements during their tenure working together, but as we'll see, the defense is going to present a letter that alleges that they actually still had a good relationship. Crawford had conducted Spokeo searches and Google Map searches for McLaughlin before the fire. He attempted to listen to scanner traffic the morning of the fire, and he had an entire PowerPoint presentation about Rich McLaughlin and all the research that he'd done in his computer. Then, July 27th, 2019, we have the fire at Scott Crawford's house. Scott Crawford, remember, is the half-brother. The two had had a fight about Crawford hanging out with his mom after his mom and dad divorced. There were photos of Scott Crawford's house on the defendant's computer. And that's basically the extent of what we have for that fire. November 17th, 2020 at 3:15 a.m. This is the third and final fire targeting Justin and Miriam Scherstrom. This fire, we have surveillance footage of the arsonist. Again, he has the same style and swagger, the hooded sweatshirt, the weird gait. He is also seen carrying bottles which match the same kind of bottles he had been using to store accelerant in. Apparently they're empty vinegar bottles. Justin's Crawford's stepson, as we've established. We know from GPS data that Crawford was on their street in the early morning hours the days before the fire, presumably scoping out the area. Crawford attempted to download police and fire scanners for the responding fire department without success in the early morning hours of the fire. Miriam reportedly recognized Crawford in the video, and his pants specifically. We see a silver sedan matching the one that was seen at the second Scherstrom fire, and samples taken from the scene tested positive for gasoline, and he was carrying those vinegar bottles of accelerant. And that's all the fires.
You set out that really fast.
I did, because we've already gone through every fire.
Yeah.
I'm just trying to recap it really fast. So we know that Crawford's being charged with arson, malicious burning, and attempted first-degree murder. So arson is the willful and malicious setting of fire or burning of a dwelling. The setting of the fire has to be willful and malicious.
So if it's not a dwelling, it's not arson?
It's not arson.
I didn't know that.
I didn't either. So burning is defined... This is what the judge had to tell the jury. The judge is responsible for giving the jury instructions, and he explained burning is the combustion or charring by fire. Willfully means that he did it intentionally, and maliciously means that it was with the intent to do harm to others or their property. So that's arson. Malicious burning is burning of property that belongs to another, and the extent of the damage has to be at least $1,000, and it has to be willful and malicious. Attempted first-degree murder. The elements of attempted first-degree murder is a substantial step beyond mere preparation toward the commission of murder in the first degree. So the state has to prove that the defendant took a substantial step beyond mere preparation. The defendant had the ability at the time to commit the crime of murder in the first degree. The defendant willfully, with premeditation and deliberation, intended to kill Russell Antico, Victoria Antico, the two Antico children, and the Antico mother-in-law, Scott Henderson, Evelyn Henderson, and their daughter. Again, willful means the defendant actually intended to kill all of the people. Deliberate means the defendant was conscious of the intent to kill. And premeditated means that the defendant thought about the killing and that there was enough time, though it may have been only brief, for the defendant to consider the decision of whether or not to kill, and enough time to weigh the reasons for and against that choice. So that is a summary of the charges and what elements are required.
Has nothing to do with your mama jokes.
Nothing.
Fine.
So this is where the state rested, and the defense immediately makes a motion to acquit on all charges, saying that the state hasn't met their burden. Now, I'm not going to go through this entire motion to acquit, because it was very long and very boring, and it didn't work. But the defense makes a motion for judgment of acquittal on all counts due to the fact that the evidence presented by the state, he says, does not establish a prima facie case as to each and every element of each and every count of the indictment. Now, prima facie means that based on first impression is accepted as correct until proven otherwise. So it's all a bunch of technical lawyer speak throughout. The judge honestly sounded bored listening to it because he kept sighing, like... And as soon as they were done, the judge explained his reasons and he denied the motion to acquit. I don't know if you know this, but when they have a motion to acquit, it's a judge's decision at that point. And the jury does not hear all of that. The jury doesn't hear the motion, doesn't hear the argument, doesn't hear the judge's response. It's all done away from the jury.
And they're just kind of like punting instead of going for it.
I think that, I would be interested to know, if you're a lawyer, I'd love to know this. Is this just like standard operating procedure in a criminal trial that once the state has presented their case that the defense tries to poke holes in saying they haven't met their burden? Like, is that just sort of standard, or is this an unusual situation?
Yeah, they just always try to get away with that or something.
I don't know.
Maybe it'll work this time. We don't.
Well, I have researched cases where the judge has granted a motion to acquit after the state rested because the state did not meet the required burden and didn't prove all of the elements. And I believe that the motion to acquit, even if it's granted, that doesn't mean that the state can't bring different charges. Like, let's say if the judge acquitted him of first-degree attempted murder, I think that the state could come back and try for attempted second-degree murder.
And that wouldn't satisfy double jeopardy.
I don't know. That's why I need a lawyer. I need lawyers. If you're a lawyer, I want to be your friend.
I'll give you a soul, because you probably don't have one.
Oh, stop.
What? I got a spare soul.
Okay. Well, then that's just a kindness.
Right.
So after this motion to acquit was denied, the jury comes back in, and this is the opportunity for the defense to present their case. And the defense did two things. They presented a piece of evidence, and this evidence was a letter written by Richard McLaughlin for Crawford when Crawford was getting his permit to carry a pistol in Maryland. And basically the letter indicated that the two still had a good relationship. So that was the defense saying that your motive is bogus, these people liked each other. And the second was a stipulation, and that was the analysis from the FBI lab that the hair fibers and animal hair fibers did not match Crawford or his dog. And then the defense rested without calling a single witness, without putting Crawford on the stand, and he has a constitutional right not to testify in his own defense. And you can't let that count negatively toward him if you're a jury member. Because it's not his job to prove his innocence, it's the state's job to prove his guilt. And so with all of this evidence, what was the defense's strategy? Well, it wasn't what I expected. I expected that, honestly, that the defendant would have taken a plea deal before any of this started. But he didn't. However, there was some pre-trial bench discussions where the judge seemed to imply that he had knowledge of a pre-deal and that negotiations weren't going well, but maybe if the prosecution was willing to, he said something like, I think 10 years is the magic number to get back to the plea deal table or something along those lines. And I can't fault the prosecution for not going for that. 10 years seems like a really light sentence for 4 fires. So the prosecution charged Crawford with 8 counts of attempted murder, 5 for the Antico family, 3 for the Henderson family, arson for the 2 Henderson fires and the Antico fire, and malicious burning for the car fire. So the defense didn't present a case, but they argued their case for the fact that they said the state didn't meet their burden in closing arguments.
That was their big plan?
So the defense began their arguments with the assertion that the state has to prove their case beyond a reasonable doubt, and the defendant doesn't have the responsibility to prove themselves innocent. And he then said that the evidence is all insufficient to prove that somebody had intent to kill anyone in these fires. And he maintained that somebody, and he never says David, obviously set these fires. But that person set these fires, and we can't prove that that person had ever intended to murder anyone. And attempted murder requires 3 elements. Premeditation, they have to take a step beyond planning, and they have to have had opportunity to rethink their decision. So let's start with the attempted murder. Bonsip says in his closing argument that reckless disregard for human life does not fulfill the requirement for intent of first-degree premeditated murder. Now, he said a reckless act is not the equivalent of attempted murder, and he goes on to say that even if whoever set these fires did intend to harm someone, but didn't intend to kill them, then that obviously still doesn't meet the requirement for first-degree attempted murder. Then he goes on in his arguments to talk about all of the fires that were included outside of Howard County. And he points out that they were introduced to establish a pattern, and they failed to do so. He said that they failed to establish a pattern of clear motive because the motive for some of the fires, like the fire for Alfonso Hawkins Sr., didn't have a motive, didn't have a disagreement that we know of. And in the Bud Price case, the only disagreement they could come up with happened 20 years ago. And so he said that because this pattern falls apart, because they don't have motive for each of them, that the jury should throw out all of the information of the other fires because this pattern no longer exists.
Have you ever heard the Chewbacca defense?
No.
The Chewbacca defense is a legal strategy in which a criminal defense lawyer tries to confuse the jury rather than refute the case of the prosecutor.
I don't know that that's really what he was doing here, but there was times during his closing arguments where I was just bored.
So it's going to be like a episode 1 defense where you're so bored you can't finish the movie.
Maybe.
Okay.
So he's saying that because they failed to establish clear motive with each of the fires outside of Howard County, that they can't use those fires to establish any kind of pattern, which is kind of throwing the baby out with the bathwater. Because to me, the pattern that we established is that Crawford had this hit list and everyone on the list had a fire, not that we have an established motive for every fire. I think even in the absence of understanding the motive for those fires, if they had just presented, this person was on the list, he did research on this person, they had a fire, that probably would have been enough for me. So he argues that there's not any evidence that's been produced to establish any motive in the Antico fire. And he's right, the jury never heard any evidence of a disagreement. However, in bench trial, we heard about the potential billing disagreement, which may or may not have actually been the motive. We don't know. But the jury never got to hear that. Then he goes through the out-of-county fires and he pokes hole in all of the motives. You know, he points out that he and McLaughlin clearly had a good relationship based on this letter McLaughlin wrote for him. And he says that in the Scott Crawford case, that he would have had no reason because he didn't have Facebook and the party invites were on Facebook, and so he wouldn't have even known about the party. And he points out that in the Henderson fire, Evelyn couldn't testify that her interruption made Crawford angry because when she stood up and interrupted him, she had her back to him. And when Scott Henderson tried to testify that Crawford looked irritated, the defense objected and it was sustained. So the jury never heard that he looked irritated during that testimony.
That's wild how that works.
And then he says that the only reasonable strained relationship that existed was in the Scherstrom case. And in 2 of those fires, the couple wasn't even home, so there was no established attempt to murder anybody, which he wasn't charged in those cases yet. And the third was of a detached garage, and the fire didn't spread to the house, and so obviously this isn't an attempt to harm anyone. And in fact, these fires go against the argument that the arsonist in this case intended to harm anyone, because he didn't. Which, I don't feel like that one holds water.
Just because nobody got hurt, his intent was not to hurt.
That's what he's saying, is that if he intended to hurt people, he wouldn't have set the detached garage on fire, he probably would have set the house on fire. And maybe he didn't intend to hurt anybody in the Scherstrom fire. But that doesn't mean that he didn't intend to hurt people in the Henderson fire and the Antico fires.
Well, I'm just going to suggest even burning people's stuff kind of hurts them.
It does. Now, in the Antico fire, the garage was attached to the house, but Bonsop argues that there was no bedrooms immediately above the garage, and the fire was set to the garage doors. And oh, by the way, look at these pictures of bicycles in these photos that are near the garage. They're fine. The fire didn't even melt the tires. Well, Mr. Bonsop, this is because heat rises in a fire, and if the bicycles had been hanging from the ceiling, they probably would have melted. But what's above the garage? A roof. And when fire gets up under that roof, where does it go? It spreads through the wall into the house where the bedrooms are. And so I'm sorry, but this argument is weak sauce to anyone that understands fire dynamics. Now, I'm not saying for 1 minute that I think Crawford is innocent, but if I was his defense attorney, I would have harped on the fact that there is a code requirement that there is a firewall between garages and living quarters. And I don't think Bonsop knew this because he never once in the trial brought it up, and it would have been Crawford's best defense against first-degree attempted murder, because then he would have had a leg to stand on to say, oh, if he knew there was a firewall there, he knew that it was unlikely that the fire would spread to the house.
I think that's one of those things that mostly just construction people and
exactly
and really just are gonna know.
So this is why if you're a defense attorney defending somebody on arson charges, you need to hire a fire expert and a building construction expert, because that would have been the thing that could have saved David Crawford from attempted first-degree murder charges. Not that I think that he should have been saved from them, because I don't think that Crawford knew that either.
You really think that could have saved him, though?
I think
knowing that there's a fire barrier between one part of a house and another. Oh, well, I guess it just makes it okay for us to light up this one part, then it's fine.
No, I don't think it makes it okay. But I think that it could have gotten reduced to second degree. That's what I think. I think Crawford did intend to murder these people. That's my personal opinion.
Why does it sound like the system is just intentionally set up to leave psychopaths like an out?
Well, here's the thing, is that I don't think Crawford knew that. Because if he had known it, he would have told his defense attorney. And it was never brought up in the trial.
Yeah, no, he doesn't know that.
So, I do think that Crawford intended to murder these people. But if I had been his defense attorney, if that was my job to defend this guy, I would have brought that up. That would have been the thing that I hinged my not sending him to prison for first-degree murder on. But
you just would have been a needling little cow, wouldn't you?
I hope not.
Sounds like it.
There's a good reason why I'm not an attorney.
Well, he knew the firewall was there. He just wanted to burn cars and fishing poles.
However, let's say that Bonsop had called me and I had explained to him that there was a firewall. The other thing I would have explained to him is that his argument that the conditions in the Henderson house weren't deadly because we could still see the area around the front door wasn't badly charred at regular person height, that argument was trash. Because we know that the items in the tops of the closets melted. We know that smoke was pouring out of the vents. And it's not heat that kills most people in a fire. It is smoke. And we know from the actions of the family and the confusion and like the trouble Evelyn had dialing 911 that the family was likely hypoxic. So that was absolutely a deadly situation that they were in. And so if the prosecution had hired me, I would have poked holes all in that argument.
Listen, folks, firewalls are built to prevent tragedy in the case of an accidental emergency. They're not meant to indemnify you from horrible arson.
No, they're not. And the thing is, and we saw it in both fires, that the fire got up into the attic area above the garage, and then it spread down along the roof line. And once you have a fire all in the attic like you did at the Henderson's house, that is absolutely a deadly situation. But that firewall is intended. Firewalls do not stop fires. Firewalls slow down fires.
Yeah, it gives you a little extra time to get out.
If that wall wasn't there, we could have been sitting in a very different courtroom that day. Well, I wasn't sitting there, but the jury could have been sitting in a very different courtroom. Because in both cases, the family woke up and got out. But I say in the Henderson case especially, they did not have much time left based on the information that I heard. Okay, so then he talks about the Henderson fire some more. He talks about how the majority of the fire damage is on the end of the house with the garage, and the interior parts of the house don't look like they were that badly burned. But again, see previous notes on smoke inhalation and deadly effects of hypoxia. He has some other arguments in there, and I'm not going to go through all of them, but he says that these are the big reasons why the evidence fails to prove the elements for attempted first-degree murder. However, the judge discusses with the lawyers several times as they are preparing jury instructions that to establish the elements of first-degree murder, aiming a weapon at a vital part of the body can convey intent to murder.
What?
So,
like, can?
That is, I mean, we're talking legal terms here, not like realistic person terms. So,
okay.
That
it seems like it definitely does.
It does, right. That fulfills the element to apply a murder charge. And the judge determined that in this instance, the aiming of products of combustion that are deadly into a home where people are sleeping is the same thing. It is aiming a deadly object toward a vital part of the body, the lungs.
Huh.
And I agree with him.
I don't disagree, but I can just think of ways where it doesn't make sense.
I can argue both sides of it, absolutely.
Yeah. But who cares? Who needs to argue both sides of that?
Nobody.
It's ridiculous.
So, suggesting that he was only reckless might fly for me if he had set the fire while people were awake, or while he didn't know that the homes were occupied. But they all had cars in front of them. It was the wee hours of the morning when people sleep. And like I said, I don't think Crawford knew there was firewalls between garages and living quarters, because I think he obviously would have told his attorney, so he can't use that as an excuse. Bonsop also harps on the fact that the analysis of hair and animal fibers found on the shoe excludes Crawford, which again we've already discussed. I don't think it excludes him. It just doesn't include him. And then he says, and this is my favorite, the PowerPoint presentation that Crawford put together of Rich McLaughlin's information, he said, this made me laugh out loud when I heard it. He said, Crawford put this PowerPoint presentation together because he was going to present it at a conference. What on earth were you talking about at this conference that you needed map searches, photos of the guy, any of this personal information about his home, and you haven't gotten his permission to use it in this conference? That is unprofessional and unheard of.
Maybe it's just a really creepy fan club.
Well, they actually did present evidence that he had been invited to speak at a conference, but they never presented evidence of like what the topic of his talk was supposed to be or how this presentation tied into it. So I don't buy it at all.
What would you call his followers? Crawfies? Crawdads? Crawdiddlers?
I would call them unintelligent. This is not the person you want to follow.
It doesn't have the word crawl in it.
Crawdingus.
Crawdingus.
And then he talked about that only after finding out that they were looking at Crawford for the fire did McLaughlin identify that the person in the video does look like he walks like Crawford. And I'll give him that. The thing is that I could throw out all the testimony about his gait and his pants, and I would still think that based on the information they found in his computers and the similarities between the crimes, that it's enough for me to say that this is a strong enough case. We don't even need the testimony about the gait, in my opinion.
Well, if I threw out his pants, I'd probably just catch a charge.
Right, yeah. So, Bonsop says the state hasn't provided the physical evidence that definitively ties Crawford to the crime, just circumstantial evidence. And I agree it is circumstantial, but it's really strong circumstantial evidence. And the biggest thing in my mind that Bonsop brought up is he said that the hit list on Crawford's phone was created in 2020, after the fires.
Well, circumstantial's not a bad word to come before evidence.
It's not.
It gets a bad rap. It's useful.
But did you hear what I just said?
No.
The biggest thing in my mind that Bonsop did bring up was that the hit list in Crawford's phone was created in 2020, after the fires. Not before, not during, not added to. And to me, if the hit list had been the only circumstantial evidence and we didn't have all of the searches and everything, that probably would have been enough for me to say there's reasonable doubt.
Yeah, because it looks like not premeditated. But
the hit list in his phone was encoded.
I was going to say, it could look like he was tracking the real arsonist.
Right. That's what I was going to say, is that maybe I could believe he was doing his own investigation.
Yeah.
But the list was encoded in his computer, in his phone. He was hiding it. And if that's what he was doing, why would he hide it in his phone?
Because the real arsonist is a man in black.
Is that what it is?
Could be.
I don't know. So to me, if he just had it in his phone, plain as day, and it wasn't encoded, I would have an easier time believing that he created the list as like an investigator, but I don't buy it at all. I believe that he was reveling in his successes and planning his next 2 fires. So I think whatever way you shake it, I personally believe he's guilty. Everyone is entitled to make their own opinions about this, and I am not a juror in this case, so it doesn't really matter what I think. But the court did make some errors according to Bonsep, and there's one particular alleged error that I quite strongly agree with Bonsep on. But is it enough to justify a new trial? Well, that's for the appellate court to decide, and they will, I believe, in February of 2025. This case is pending appeal right now, and in the next part, I'm going to cover the grounds for appeal, and maybe we'll have those investigation reports for those possibly unrelated but similar circumstance kinds of fires. And if not, rest assured that I will keep plowing ahead, and if we wrap this case before I get that information, we'll just do a supplemental episode. So tune in next week, and I think that's probably going to be our last episode of this case until the appeal if we don't get those investigation reports.
Sayonara, David Crawfish.
I was really surprised that the defense didn't present. I expected the defense to come out with fire experts to refute the cause and origin evidence, and they didn't.
That's because you are a fire expert.
I am, and I know how difficult it is to interpret. Post-fire evidence. I think that the experts that they had testify, especially the one that testified on the Antico fire, was really, really good. He presented some really interesting points, but understanding fire dynamics after a fire is not an exact science, and there's a lot of room for interpretation a lot of times. There's a lot of people that have gone to prison for a really long time because of junk science, which is why I did a whole series of arson investigation myths.
They would have been better off having De Niro investigate it.
From
Powerful
Backdraft.
Investigator.
I forgot about Backdraft.
He's a serious investigator.
I know. And you remember in Backdraft when they talked about the light bulbs deforming toward the fire?
Oh, yeah.
You know, it depends on the wattage of the light bulb.
What does?
Which way the light bulb deforms, whether it's toward the fire or away from the fire.
What if it's an LED bulb?
I don't know, actually, what happens with an LED bulb. Maybe we could test that.
Not down here.
Not down here, but, maybe we could build a little box and put a light bulb in it and see which way it deforms. Outside. Or not. I haven't set any fires since I set the driveway on fire with that magnesium fire.
Is that true?
Yeah. Oh, well, I've tried to light the wood stove, but I'm really bad at it.
Oh, Lord.
I'm such a good fire protection engineer, I can't light our wood stove.
Have we told people that story?
I don't know. So in the winter, our house is designed to be fully heated by wood stove, and the wood stove actually outruns the central heat. We almost never run the heat in the winter. We just keep the wood stove going. But that means that usually, we put the kid to bed relatively early, and then we sort of turn in around that time. And so one of us needs to come down in the middle of the night, usually right around midnight or so, and restock the wood stove with wood. One night, my husband had fallen asleep, and I fell asleep, and so it was way past our normal time to restock the wood stove, and so I woke up, and I came down here, and there was just a few small embers, but they were not going to be enough to get the fire going again. So I put some kindling in there, and some logs, and a piece of fat wood, and I got one of those matches, and I lit it up, and I made sure that the flue was open, and it was set to full vent to get it going. And I sat there and I was exhausted, but I sat there and waited until I saw flames in the door. I closed it up and went back to bed. only to find in the morning.
Well, I didn't realize that you had done that, and I realized that I'd, overslept or whatever, but I came down. I didn't realize you'd already come down, and I went to go load up the wood stove, and I opened it up, and I saw that it was already loaded up. It's like, oh, that's convenient. And then I looked a little further, and I was like, why is the fat wood on top of the wood?
It wasn't on top. It was
and
under.
Why is this... There's a match sitting on top of that piece of fat wood. Like, the stick part of it's not even burnt. Like, it just burnt the match head. And nothing ever happened in there.
The match must have shifted because I put the match under the fat wood because I know the fire burns, the heat goes up. No, I would not put the fat wood under the match. That would be stupid.
That's not what I said.
Okay.
You didn't put the fat wood under the match. You put the fat wood on top of the rest of the load that was in
But I didn't.
I opened up the top of the stove, and there it was, piece of fat wood with a partially burnt match sitting on top of it. And I was sorely confused.
I wouldn't have done that. I know you can't do that. That's stupid. Fire burns
I
up.
didn't say stupid. I just saw what I saw.
Anyway, so the moral of the story, regardless of where the fat wood was in the stove, is that I'm a very good fire protection engineer. I can prevent fires, even in wood stoves.
I like to think you're a ninja-neer.
A ninja-neer, yeah.
You protect people and they don't even know you're there.
So yeah, I am incapable of lighting a wood stove, apparently. I have successfully lit the wood stove, but that's the story that gets remembered, is the one time I was just way too tired and I wasn't really paying attention apparently to what I was doing, and as soon as I saw any little bit of flame through the door, I was like, there we go! Off to bed!
We're good.
It's gonna light right up, surely. Whoops.
Just wind just whistling through the air returns.
So that was probably the one night last winter that the heat got to work.
Yeah, the heat pump got to kick on one night. It's pretty efficient.
Yeah. Anyway, if you have a fire case that you would like for me to cover, or you have a fire story that you'd like to share with me, please reach out at crimetoburn@gmail.com. And of course, as always, if you have any information on this case, or any information you think we've gotten wrong or that needs correcting, please reach out to me at crimetoburn@gmail.com.
Because you're the smart little pig that built that a brick. Alright then, let's spank this crime donkey.
Can't do it all by me onesie.
We're spanking a crime donkey is what we're doing. I'm the isolated gringo.
Lonely.
I feel like I may have taken you down a bad road.
I'm just here for your extra time and your kiss.
You don't have to make sense to be my girl.
That's good, because I rarely do.
Breathe, my pasty friend. I was going to say something here. Oh, I thought you were just being a cruel mistress.
I don't know what I do know what botulism is. I don't want to be on botulism. That doesn't sound like a good place to be.
What's that stuff you get from cow tits?
Milk? I don't know what we're talking about.
The disease.
You just gave me a look like, did you really just say that?
I'm not a farmer.
We're not a farmer. We're not even two farmers. Now we must wait for all the critters in the house to settle.
Chewbacca was a Wookiee.
Anyway, I'm gonna cut all that out. We need to put you to bed.
Well, can you imagine people walking up on that? It looked like an alien abduction happening in my tent or something.
Signing off. Until next week.